Welcome to Stanford Legal, where we look at the cases, questions, conflicts, and legal stories that affect us all every day. I'm Pam Karlan, along with Joe Bankman.
Hi, Pam. Pam, today we're going to be talking about unions in the Supreme Court. And as background, union members tend to make more than non-union members, but union membership has been trending down for many years. The bright spot is in the public sector, where about a third of the employees are unionized. But a recent Supreme Court case threatens to overturn the apple cart, at least for the unions.
And today we have with us to talk about this probably the best possible guest we could have, our colleague William B. Gould IV, Stanford's Charles Beardsley Professor of Law, Emeritus. He's a nationally recognized expert on unions, on labor law, and on discrimination law more generally. He served as chairman of the National Labor Relations Board, which is the federal government agency responsible for overseeing the unionized sector of the American workforce. And he's also served as chairman of the California Agricultural Labor Relations Board, which oversees farm workers and their working rights in California. Bill has written huge amounts of scholarship, including my favorite, a piece that marries two of his passions, Bargaining with Baseball, Labor Relations in an Age of Prosperous Turmoil. And Bill, along with several of his labor law colleagues, participated as an amicus curiae before the Supreme Court in the case we're going to be talking about, the Janis against Afscme case.
Why don't you explain a little bit, Pam, on the background of Janus to kind of set the stage for how this case is set up?
Sure. So the way that unions work is when a majority of the workers in a company or in a government agency want to be represented by a union, the union becomes what's called the exclusive bargaining agent. And it negotiates contracts that set the terms of employment with the employer. And it also represents individual workers when they have problems on the job through a grievance process or the like. Now, the way that unions finance themselves is through dues paid by their members. So you've agreed that you all want to be represented by a union, by a majority, and then people pay dues. But sometimes people don't want to join the union for whatever reason. And one of the things the Supreme Court said many years ago is that unions could charge these people the cost of representing them, even if the people didn't want to join the union's other aims, which can often involve political activity and the lot. And so they did something called agency fees or fair share fees, where you don't pay the full union dues, but you pay the cost of negotiating the contract and the cost of the grievance process.
So you could think of it a little bit like a democracy. You're represented by the union even if you don't want to. You benefit from the union. You have to pay something that a little bit like taxes, your share of the costs. But in return, the union has to represent you. And if you don't like what they're doing, you got to vote them out.
That's right. The idea behind this is the union has something called the duty of fair representation. It has to represent everybody in the bargaining unit, whether they support the union or they oppose the union. In the same way that your representative has to perform constituent services, whether you voted for him or against him or voted him out of office.
And this is really why we call this a system of self-government, a private system of self-government, because it's very similar to the political process itself. We vote for people, and sometimes our candidate doesn't win, and they do all the horrendous things that we anticipated that they would do if they did win. And there's really not much we can do about it except try to get them out of office the next time and vote in others that we want. And we really, our pitch to the Supreme Court was that this system, which resembles the political process and really was modeled after the political process when the National Labor Relations Act, covering the private sector, was first enacted, should be the guidepost that we would look to in determining what unions can do.
And what happened in the Janis case and in a series of cases that led up to it, this was one of these cases that I think every observer of the court knew was coming for quite a while, because the court seemed to have embarked on a project here, was to allow the people who did not want to join the union to also object to paying the fair share or agency fee. That is, they wanted to claim that it violated their constitutional rights for the government to require them to pay for what the union did in collective bargaining.
This dispute really arises in the private sector initially under the National Labor Relations Act when the Congress amends the statute in 1947. Senator Taft, one of the principal sponsors of the so-called Taft-Hartley amendments, likes an idea which originated in Canada, a so-called agency fee arrangement, and says, well, everybody shouldn't be compelled to be a member of the union, but they should be obliged to pay for the services that the union performs for them in negotiating and administering the collective bargaining agreement. And out of this comes a great deal of litigation. First, under the Railway Labor Act, which was enacted in 1926, where non-union workers say, hey, look, we shouldn't be constitutionally, it's an interference with our constitutional First Amendment rights to have to pay the union dues. And the Supreme Court says no. There's a demarcation line between dues that are used for collective bargaining purposes and dues that are used for political purposes. And under the Taft-Hartley amendments, so-called right-to-work laws are authorized for state legislation. These laws are a misnomer. They're not a right to work. They're rather a right not to be affiliated by a union, even though a union has won the right to represent you through the majoritarian process.
So, Bill, you're talking about what happened in the past, and we're describing this kind of democracy system. You wanted this to continue, I take it. And what did this? And the Supreme Court said no.
Yeah.
So what did they say? What's their rationale? Because you're making it sound like it was a pretty good system before.
Yeah. Well, the Supreme Court in 1977 had taken this model that I described under the National Labor Relations Act and under the Railway Labor Act and said the only First Amendment right that an objector, a person who doesn't want their dues spent, has is to object to dues that are spent for political purposes. You can't object to dues that are spent for negotiation and administration of the agreement. Now, between 1977 and 2010, when the first of these cases began to come up since the court has become more conservative, between that period of time, basically nothing had changed except that public employee unions had suddenly become very successful in organizing workers and negotiating these kinds of fair share agreements. And the Supreme Court said, look, not only has a great deal changed since 1977 when we said that these kinds of agreements are okay, but public spending has emerged.
Yeah, and if I could stop you there for just a sec, Bill, as I understand the argument of the people who are challenging this, they were saying essentially there's nothing that a public sector union does that isn't political, because if it asks for more money for teachers, that's a political position. If it asks for restrictions on the amount of overtime that can be required, that's a political position.
Yes.
So everything they do is political.
Right.
Is that?
Right. That's the idea. The Supreme Court said that two things. One is everything they do is political because they're public employees. The Supreme Court had always said that public employees did not have a First Amendment right as a general matter regarding the workplace, but only to issues outside the workplace. But the Supreme Court in this case ignored that precedent, the so-called Garcetti decision in 2006, and said that a union offended the First Amendment.
This is Stanford Legal, and today we're talking with Bill Gould about the Supreme Court's recent labor decision in the Janis against Afscme case.
So let me get this straight. Under this Janus decision, the mere act of negotiating for me, if I'm a public sector union, is political, and if I have to support that, that's a violation of my First Amendment right. Even if I'm paying for lawyers that are looking over my health benefits, if I have to pay you to do that, that violates my First Amendment right.
Yeah, there's a First Amendment right to object to having dues spent to the union for any purpose. All purposes are political. The Supreme Court said that one justification for the new rule, repudiating stare decisis, in the Janis case was that there had been all kinds of fights about what was political and what was germane to collective bargaining, dues spent for that purpose, which was okay, and what was political, where people could object to the payment. In fact, as Justice Kagan pointed out in dissent, there had been very precious few cases that had emerged in the circuit courts as well as before the Supreme Court involving the question of what the demarcation line would be and how this should be characterized.
So the problem, I take it, for the unions is that if they can't charge their members through dues and they can't charge the non-members through an agency fee, they become less effective at...
Well, yes, and as Senator Taft said when examining this during the Taft-Hartley amendments, this creates the so-called free rider problem, where, and this was a justification that the Supreme Court had put forward in 1977 in the public sector Abood case, where this principle of authorizing these kinds of agreements was first established. If you can't charge every employee within the bargaining unit monies for the purpose of negotiating and administrating the contract, then you create an incentive for everyone to be a non-member, because everybody, be they union or non-union, gets the benefits of the collective bargaining representative, the union acting as the collective bargaining agreement, the union acting as exclusive bargaining representative.
So, Bill, I think it might help our listeners a little to get a sense of the magnitude of the cost here. What does an average agency fee look like for somebody who doesn't want to join the union? How much are they paying?
Well, they could pay anywhere from $10 to $15 to $20 a month, which would automatically, in an agency shop, automatically be deducted from their wages. And the significant.
So can I ask you a question? If we're talking about $120 over the course of a year, or say $180 over the course of the year, why would somebody take that case all the way to the Supreme Court?
Well, the reason they take it to the
who took the cases to the Supreme Court?
A number of groups, the National Right to Work Foundation, who's organized around the question of eliminating these kinds of fair share agreements, and they feel that by eliminating these agreements, they can weaken unions. Unions will have less members, less dues, and less influence. When I was chairman of the Labor Board, we had many cases before us that were akin to this, and the Republicans in the Congress were particularly interested in these cases because they see, correctly I think, the unions as, in many instances, allies of the Democratic Party. And much of the monies that the union uses and obtains is used for the purpose of the political process as well as the collective bargaining process. There has been a duty to object on the part of the person who doesn't want to have their money spent for political purposes. Now, the union can't obtain dues in the public sector on any basis unless there's affirmative consent, for what we call an affirmative opt-in, the British call contracting in, to authorize the union to obtain these monies. And that creates a radically different situation where unions will be inevitably influenced unless they're able to do some other things. But in my view, there's not a second best.
This is Stanford Legal, and today we're talking with Bill Gould about the Supreme Court's recent union decision in the Janis case.
So as I'm hearing this, it reminds me of this line on our federal tax return saying, do you want to donate anything extra? Because you can always do it, but you get represented whether you do it or not. And what we find is surprisingly almost nobody decides to pay anything extra.
Yeah.
So if we have the democracy analog, if I'm a public sector worker, there's no incentive for me to pay anything extra. It's like a voluntary contribution to the unions. And the unions then are going to be living on what amount to these voluntary contributions.
Absolutely. The unions will be weakened considerably. They'll have less finance. This has been a great debate in the political process for years. You know, here in California, Governor Schwarzenegger proposed legislation which he put in the form of a proposition on the ballot, which was repudiated by the voters of California, requiring all public sector workers to affirmatively consent. And this is an aspect, you see, of the Janis case that I think must get a lot of attention. The authors of the Janis opinion for years railed against the opinions of the Warren Court, which were liberal and which promoted the Bill of Rights. And they said, this is judicial activism. The judiciary is engaged in a process which is really part of the political sphere of life. Well, that's exactly what this is. This is judicial activism. What the court has done is say, we don't like the fact that public employee unions have become successful, and we don't like what they've done at the bargaining table because they're responsible for all the overruns and all the bankruptcies we see now in government. And so this is, and they say this in the Janis opinion, but this, in my view, is a matter for, as Justice Kagan said in dissent, a matter for the political process and not for the judiciary.
What's the breakdown, Bill? It seems like this is intensely political, as many Supreme Court decisions are. You've mentioned a dissent. Is this a 7-2 decision, a 5-4 decision, and who's on what side?
Yes, all these opinions, beginning in 2010 with a case here in California, the Knox opinion, have been 5-4 votes. The Roberts, Alito, Thomas, Gorsuch, and the other name escapes me at the moment.
Justice Kennedy.
Justice Kennedy.
And then Justice Alito Justice Scalia when he was on the court.
Yes, when he was. Although the interesting thing about Justice Scalia was, in the 1990s, he wrote an opinion, the so-called Leonard case, where he said that a union could appropriately require dues in a collective bargaining agreement, which would be for the purpose of representing workers under any subject that they had a duty of fair representation to represent them on. Then when these cases in 2010 and 2014, the Quinn case, Quinn against Harris, came along, Justice Scalia, prior to his death, forgot all about his opinion in the 1990s. And, of course, the dissenters were, as I indicated, Kagan and Justice Sotomayor and Ginsburg and Breyer. It was a 5-4 lineup in all three of these cases, which culminate in the Janis case.
Well, one of the things I was going to say is that both in the Friedrichs case and in the Janis case, our clinic helped to represent public sector safety unions in California. And one of the points that we made was that unions do a lot other than simply transfer public wealth into the hands of individual union members. And we showed things like, for example, how CAL FIRE ended up negotiating deals that made it easier for different firefighters in California to use the same equipment across departments. So it's kind of interesting, the range of things that public sector folks bargain on.
Well, I think also the range of things that the labor movement bargains on generally. The labor movement was a historically a protest movement. It's difficult, I think, if we look back to the beginnings of the labor movement to speak in terms of political and economic objectives. It was a protest movement which took many different forms, seeking legislation, minimum wage, health care, and the like, and also in seeing legislation and seeing improvements in the collective bargaining agreement for their members, and attempting to establish, particularly in the public sector, rapport with the public which it serves.
Well, we'll be back with more from our guest, Bill Gould, talking about the Supreme Court's recent decision in Janus in a moment, next on Stanford Legal on Sirius XM Insight 120.